Section 21. What foreclosure really means in Arizona. Let's rewrite David's ending. David's short sale successfully closed in Chapter 4, but for the next few sections, we're going to rewind the story and change one important fact. Imagine Marcus and Elena never made it to closing. Maybe their financing failed. Maybe the short sale lender rejected the proposal. Maybe the second lien holder refused to cooperate. Whatever the reason, David still owns the Queen Creek property. He is still behind on his loan, and his financial problems have not disappeared simply because the purchase transaction failed. 2 weeks later, David calls Ashley. "I got something in the mail that says notice of trustee's sale." Ashley immediately calls Michael. This is the point where understanding Arizona foreclosure law becomes extremely important. Foreclosure is a process, not a single event. People often say, "My house is in foreclosure," but that phrase can describe different stages of a process. A borrower may have missed payments and received collection notices. A creditor may have begun formal foreclosure activity. A trustee's sale may have been scheduled, or a judicial foreclosure action may have been filed. Those situations are not identical. As an Arizona real estate professional, you don't need to become a foreclosure attorney, but you should understand enough to recognize what process your client may be facing and why the timeline matters. The first question Ashley should ask David isn't, "When are they taking your house?" It is, "What exactly did you receive?" Arizona has more than one foreclosure path. Arizona law provides for judicial foreclosure of mortgages under ARS Section 33-721 and related statutes. In a judicial foreclosure, the creditor uses the court system to pursue foreclosure. Arizona also has a statutory process involving deeds of trust. Under ARS Section 33-807, the trustee may exercise the power of sale when the applicable legal and contractual requirements are satisfied. That second process is commonly called a trustee's sale, or non-judicial foreclosure. Why non-judicial? Because the creditor generally does not need to first complete a traditional foreclosure lawsuit and obtain a court judgment before the trustee exercises the statutory power of sale. For Arizona residential agents, this distinction matters because deeds of trust are commonly used to secure residential loans. Meet the trustor, beneficiary, and trustee. David looks at his deed of trust and sees terminology he never paid attention to when he bought the house. Michael explains it in plain English. David, as the borrower property owner who conveyed the trust property under the deed of trust, is generally the trustor. The party for whose benefit the deed of trust exists is the beneficiary. This is associated with a lender or a successor to that interest. Then there is the trustee, the party with the statutory and contractual role connected with the power of sale. These terms may sound technical, but once you understand the players, the process becomes easier to follow. When David defaults, the beneficiary does not simply show up at his front door and take the house. Arizona statutes establish procedures governing how a trustee's sale occurs. Judicial foreclosure and trustee's sale are not interchangeable. Here's where many agents get into trouble. They hear something about foreclosure law and repeat it as though it applies to every foreclosure. For example, someone might tell David, "Don't worry, you'll have a redemption period after the foreclosure sale." Maybe, but you first need to know what type of foreclosure we're discussing. Arizona law contains redemption provisions associated with certain judicial sales. But a completed trustee's sale under Arizona's deed of trust statutes is different. Agents should not casually apply judicial foreclosure concepts to a non-judicial trustee's sale. The same caution applies to deficiency liability. Different foreclosure methods, property characteristics, loan circumstances, and statutes can affect the analysis. This is exactly why David may need an Arizona attorney before making major legal decisions. Listing the house does not stop the clock. David asks Ashley, "What if we put the house back on the market today?" That should stop the trustee's sale, right? No, listing a property does not automatically stop a foreclosure process. Neither does receiving an offer, neither does opening escrow, neither does submitting a short sale package. Until the appropriate party confirms that a trustee's sale has been canceled or postponed, Ashley should not represent to David that the sale is stopped. Imagine the consequences if Ashley tells David, "Don't worry, the lender knows we're selling," and everyone later discovers the trustee's sale continued as scheduled. That's not a small communication mistake. That can change ownership of the property. Now Ashley looks at the notice. Michael asks David to provide the actual notice of trustee's sale. He doesn't want David's memory of what the notice said. He wants the document. There is a scheduled sale date. Now the transaction has a very real clock. Ashley looks at Michael. "How much time does he have?" Michael responds, "Now we're asking the right question." Arizona law establishes specific requirements surrounding a trustee's sale, including notice and timing provisions. Understanding those requirements helps an agent recognize how urgent a distressed property transaction may be. In Section 18, we'll examine the Notice of Trustees Sale, Arizona's statutory timeline, and what every Arizona real estate licensee should understand when a foreclosure date appears on the calendar. Online Discussion 1. David tells Ashley that his property is in foreclosure. What should Ashley determine before making assumptions about what happens next? Answer. Ashley should determine what process has actually begun and review reliable documentation. She should identify whether David has merely received delinquency communications, whether a notice of trustee sale has been recorded, whether a judicial foreclosure has been filed, or whether another stage has been reached. Different procedures can create different timelines and legal consequences. 2. What is the basic difference between judicial foreclosure and an Arizona trustee's sale? Judicial foreclosure generally proceeds through the court system, while Arizona's deed of trust statutes permit a trustee to exercise a statutory power of sale when applicable requirements are satisfied without first completing a traditional foreclosure lawsuit. The procedures should not be treated as interchangeable. David asks Ashley whether relisting his property will automatically stop the scheduled trustee sale. How should she respond? Answer. Ashley should explain that listing the property, receiving an offer, or attempting another short sale does not by itself guarantee that a trustee sale will stop. The status of the scheduled sale should be confirmed through reliable sources and appropriate parties, and David should obtain legal advice when necessary.